Now I am going to dictate a legal passage at the rate of 100 words per minute based on latest Supreme Court judgment. Let's start. Mr. C.A. Sundaram, learned senior counsel for the appellant, forcefully contended before us that the appellant, after paying the full consideration, obtained a registered sale deed in his favor and is therefore entitled to the protection of his interests in the subject land. He argues that impleadment of the appellant in the underlying suit is necessary as there exists a real possibility of collusion between the plaintiffs and the original defendants. To substantiate his claim, learned counsel highlights that the plaintiffs and the defendants are relatives. Further, he points to the considerable delay in the filing of the underlying suit about 12 years after the execution of the release deeds. Stop para. On the legal issue, Mr. Sundaram asserts that there is no bar to the impleadment of a transferee parentalite even when the transferee has prior knowledge of pendency. To buttress his contention, he points to the judgment of this court in Thomson Press versus Nanok Builders (2015) 5 SCC 397, wherein after considering all the previous judgments on the question of impleadment of a transferee parentalite, this court permitted the impleadment of a transferee in a suit for specific performance who not only had notice of the pendency but also had knowledge of the injunction prohibiting any transactions relating to the subject property therein. Stop para. Par contra, Mr. V.K. Shukla, learned senior counsel for the plaintiffs, contended that the appellant is not entitled to impleadment as he is not a bona fide purchaser. He argued that despite having knowledge of the pendency, no permission was sought from the court to execute the RSD, and hence the appellant is not entitled to any relief. To buttress his contention, reliance is placed on B.B. Jubaida (Supra), wherein this court held that transferees parentalite cannot, as a matter of right, seek impleadment in that case. This court upheld the decision of the trial court rejecting impleadment on grounds that the transferee was not bona fide and was only attempting to complicate and delay the pending suit. Stop para. Mr. Shukla also contends that the judgment of this court in Thomson Press (Supra) is entirely distinguishable on facts from the present matter and is hence inapplicable to that extent. He highlights that contrary to the factual position in Thomson Press (Supra), in this case the title of the appellant itself is in question, and additionally the appellant is not in possession of the subject land. Stop para. Going a little further, Mr. X, learned senior counsel for the respondent number 21, contends that the appellant cannot seek impleadment as he is not even a purchaser of the subject land. Mr. X submits that out of the 6 checks issued under the RSD, 2 checks bounced on 01/10/2018, rendering the consideration unpaid. He highlights that the RSD contains an express clause to the effect that if the payment made under the 6 checks are not completed, the purchasers will not receive any legal rights over the subject land through the RSD. On the question of unpaid consideration, Mr. Sundaram asserts that the entire consideration was paid by the appellant via RTGS. Stop para. He further highlights that this contention was neither raised before the ADJ nor the High Court and is merely an afterthought, pointing further to the appellant's suspicion of collusion between the parties. It is also brought to the notice of this court that respondent number 21 previously filed a suit for declaration to the effect that the RSD is null and void, but the same was dismissed in default on 28/02/2020. Para. We have heard the learned counsel for the parties and have carefully perused the record. The factum of the dispute herein concerns the implement of a transferee pedantillite who undisputedly had notice of the pending litigation. Stop. Thank you.